How does somebody transfer the rights to their likeness?
These rights are not freely transferable, point A. That's partially because they're really not property. This is not intellectual property. Copyright's freely transferable. This is the whole point of copyrights is to allow you to transfer to publishers, to other artists, to this, to that, licensing, royalties. It's a whole system. Whole point of patents, same thing. Licensing for deals, licenses, exclusive licenses, carve out territories, all that. This is not a property right. The state right of publicity is not a, quote, property right. And one of the implications of that is that it's not transferable in quite that same way. I don't have a... Can I transfer... So let's ask that question about, say, the negligence. I have, David Post, an enforceable right, if you will, to be free from harm from the negligent actions of others. We all have that. You know, if somebody negligent, or I walk out of the law school, someone negligently harms me, I have a cause of action against them for the damages. I can't, in most circumstances, I can't transfer that to you beforehand. This is a very funny area of the law, but generally speaking, we don't like people trading causes of action. We like people trading property. It's the point of property. Get it moving, markets, all that. The American legal system is very uncomfortable with the notion that you can actually have a market in causes of action, including even causes of action that haven't accrued yet. So if I'm a famous person, exactly how I accept through death, I'm not sure, actually, that I can transfer my right of publicity to a third party in the sense of a true transfer. Transfer my right of publicity such that I don't have it anymore. It's conceived as a person. It's personal to me. What I can do is I can license others. If I'm Michael Jordan, I can say, Hanes T-shirts, you can use my likeness. Give me, we'll have a contract. Give me this much money. I hereby license you to use it. Technically speaking, he hasn't transferred his right of publicity to Hanes. He's licensed them to use his likeness in a way that they would not otherwise be able to do. I don't think you can actually transfer your publicity right because it is personal to you. If Michael Jordan he can't sell his right to the Michael Jordan likeness to Coca-Cola Inc. and then be done with it. Then it would be odd because then he wouldn't even have it. He could put his own picture on Christmas cards, presumably, without Coca-Cola's permission. Wouldn't make any sense. This whole publicity thing, I mean, this was just by way of background, I mean, this was a pretty dormant, really a fringe area of law up until maybe 20 or 30 years ago. A handful, a smattering of claims under rights of publicity. For a lot of reasons, including technological reasons and just the market for content and stuff and video games and movies and the explosion of all that, these claims have sort of grown up over the last 20 or 30 years. And I think the law is very unsettled about lots of very basic questions about them because it hasn't really been wrestling with them for too long.
This is primarily an antitrust case. Have the rights to publicity ever been connected to antitrust before?
There was a very famous series of cases many years ago. I think this goes back to probably the 50s, when I was very young and collecting baseball cards. The Topps bubblegum company had an exclusive arrangement of some kind with the baseball teams. You could only get... Topps was the only supplier of baseball cards. You want baseball cards, you bought Topps baseball cards. The only ones that existed. That was quite lucrative for them, actually, and it was not an accident. It wasn't that nobody else was interested in. Major League Baseball would not permit others to use the likenesses. Major League Baseball controlled the licensing of the likenesses of their players, and they had worked out an exclusive arrangement with Topps. I believe that was challenged, pretty sure that was challenged and broken up. One of the reasons there were, starting in the late 60s, early 70s, suddenly there were dozens of different companies with baseball cards. You could buy baseball cards from all sorts of other people. That was the result of an antitrust action. I believe that the plaintiffs in this case are alleging that the NCAA and EA Sports have combined, that's the unlawful combination in restraint of trade. They have, in effect, and again, this is the plaintiffs are alleging what the NCAA has done by giving permission to EA Sports to use these players when they didn't get the permission from the players themselves, that they are restraining trade. Now Mr. O'Bannon can't go to another video. I mean, the idea is he's not free to peddle his likeness to another video game distributor because it's already been taken, in effect, by EA Sports, and they are claiming that that is a violation of antitrust.
If the players win, what happens next for EA Sports?
The court would probably order a special proceeding at that point to look at the question of what do we do. They probably entitle the plaintiffs to an injunction. They can get the game off the shelves. Although even that, if the judges are smart, and they usually are smart about things like this, they realize that it's just about the money. Most of this is just about the money. So rather than wasting a huge amount of money, I mean, the cost of recalling all versions of whatever it is, NFL 2012 or whatever the EA game, the cost of actually pulling them back from the retail stores is immense. And the judge might want to put the parties in a room together. Now that I've ruled, they've won, now you guys go and work out a deal. That itself can take years. I mean, there's a lot of precedent for this. It reminds me, it's very reminiscent of, there was a Supreme Court case that is now, I don't know how, 6, 7, 8 years old, and in copyright law, the Tassini versus the New York Times, which was a class of freelance authors whose works had been used by the New York Times and many, many, many other publications. So it was a class of potentially hundreds of thousands of potential plaintiffs, all these freelance authors. Many of the largest circulation newspapers and magazines in the country were the defendants. The plaintiffs said that the publications did not have they had the right to publish their articles in the newspaper, but not in the electronic databases. Plaintiffs prevailed in the Supreme Court on that. It was a violation of their copyright to do what the Times did. They could have enjoined, they could have sought an injunction against the operation of the Lexis database, I suppose. I mean, you know, and the publication, you pull back all those copies of the New York Times from Lexis, X out. That would have been enormously costly for all sides. What the judges do in that circumstance is they put the parties in a room together, they close the door, and they say, work out a settlement. That's a waste of money. It's just, you're going to have to, New York Times and all of you publications, you're going to have to pay them something for this. Figure out how much, work out, and they work a very complicated, it took them years to do that actually, very complicated formula of how much they pay based on usage and how the money gets transferred back to the authors and all of that, which is the same problem here. You have this class of how much money does everybody get? It's not obvious how you would even calculate that. If you're talking about thousands of players whose likenesses appear, they're each entitled perhaps to something. How much, and is it more for the superstars, and all that stuff will get worked out. We first got to decide, are we liable at all? If they're not, then, you know, shake hands and they'll get out of court and say goodbye, leave me alone. If they are, in a sense, really a lot of hard work after that, huge amounts of hard work after that. That's invisible to the public. That's, case is over, plaintiffs win, then the hard work starts, actually, figuring out, okay, now what do we do?
Do you think that the current situation is fair to student athletes?
Do I think it's fair? No, I don't, actually. I mean, I think as far as the NCAA is concerned, it's hard for me to see what their claim is that would trump the individual's claim. But I think this is part of a larger debate about the NCAA's ability to extract money from student athletes and not give them much of a piece of it is sort of the bottom line on this and many other things that are happening in the news. I mean, there's just been an enormous amount of publicity of late to this question: is why aren't they getting paid? These, you know, the amount of money in college sports now, including from things like EA Sports licensing fees, are gigantic. They run into the tens of billions of dollars, and the students get a scholarship and a handshake when they have a valid claim that it's there. They make the whole system go. The NCAA has no product, of course, if they don't have these athletes. So it certainly starts life. It's a more complicated problem than that, and it is complicated, but it certainly starts out life in my brain as saying something smells a little fishy about this. Why do they get to keep the money that would seem to belong to the individual? Now, there may be good counters to that. The burden of proof for me is on the NCAA shoulders, and it's everyone to explain to me why shouldn't this guy get his likeness? I mean, as quarterback of Ohio State, why shouldn't he get a piece of that?